Hey, everybody. Welcome to Thursday night. I've got to come up with some kind of catchy name for this. Thursday night, we're here. We're doing a live stream here on the Consumer Warrior YouTube channel. I appreciate all those who check in during the live stream, as well as the people who watch it afterwards. I appreciate that. So I always give my spiel, the beginning of this as far as what we do here. This is really just an opportunity to talk about different topics related to debt collection lawsuits, bankruptcy, all the other miserable debt type things that we're dealing with when it comes to the legal side of things. I am an attorney in the state of Arizona. However, I am not licensed anywhere else. And so my disclaimer I give each and every week is that I cannot give legal advice. I don't live where you live. I don't know the laws in your state. I don't know the procedures. I do know some of the general ways that particularly junk debt buyers handle things, but I don't know that. And so don't take this as legal advice. If you need an attorney, get an attorney in your area. I think I've mentioned before where I recommend if you're looking for counsel outside of the state of Arizona, because obviously if you're in Arizona, you're going to call me. But if you're outside the state of Arizona, go to the National Association of Consumer Advocates. Their website is consumeradvocates.org. They have a listing, a directory there for attorneys who do the kind of work that I do in your particular state. So this also doesn't create any attorney-client privilege. One thing, I do get emails on a pretty regular basis from people. In general, I can't respond to them just because it doesn't create an attorney-client relationship. And there's just the whole legalities that I know are kind of annoying to the rest of the world, but attorneys take pretty serious. So let's go ahead. And if you want to have a topic you want to discuss, go ahead and put it in the chat box there. And we'll go ahead and put it up on the screen and just go over what you want to discuss tonight. Now, first name, last name was here bright and early, well before. Boy, I got to get my chair up or something. This, the questions drowning me out here. But this is a good one I think we could start with here. He says, I worked out a payment plan with a credit card company that was suing you to pay $35 a month for 6 months, then $200 a month. Would I be able to renegotiate after the first 6 months to get that lower? I'm just going to hide this just because it's covering my whole face. It's a good question. So we call that a step-up plan where, you're paying off a certain lower amount and then at a certain point, 6 months down the road or whenever, it jumps up to a higher payment or maybe a balloon on the end like you're doing there. Let me give you some basic principles of contract law though. And that is if you have an agreement in place, if you've negotiated a settlement and you're making payments on that, and then you go back and you try to renegotiate it, it's possible for them to basically say, okay, we don't have a deal anymore, and go back to maybe the higher amount or come back with something that's not as favorable. So you got to be really careful and kind of play that one by ear. How is the lawyer or the debt collector that you're working with? Were they pretty easy to work with before? Were you on time with your payments previously leading up to that? Those are the kinds of things you got to be careful of and be aware of when you go and try to renegotiate it. Does it happen? Yeah, absolutely. We go and renegotiate debts all the time, but I'm always careful, particularly if it's a large debt. You don't want the whole thing to come crashing down just because you try to essentially kind of back out of that. So I do got to give a shout out to Dave Lamb, who's here each and every week, 111 degrees in Apache Junction today. We were just stating before we went on the live stream, this is the time in Arizona when you're not sure what you're doing here. I've lived here for almost 20 years, and every summer I ask myself that question. Winters are nice, but it doesn't make up for it. I would rather have snow than 115 that I'm going to face when I'm driving home tonight. So, all right, let's talk about, let me see what else we have here. Let's see. All right, another settlement question. If settlement was agreed and paid majority, but not completely due to hardship, the plaintiff sues the original amount, but doesn't include the settlement. Can you have the case dismissed? This is a good question. So essentially, if I'm getting it right, you entered into a settlement agreement, you were paying it as agreed, something came up and you weren't able to finish the settlement, and then they're suing for the original amount. They've got to give you credit for the amounts that you paid. And so if they're suing you for an amount that's less, or that's, if you owed $10,000 and you paid on this thing for 3 years, and now they're coming back and they're suing you for $10,000, assuming that interest hasn't accrued, that would bring it back up to that original balance. If they're just not giving you credit, it's not a basis to have it dismissed, but it's definitely a basis to contest it. because there's two parts to any debt collection lawsuit. They've got to show liability. They've got to show that you're contractually responsible for the debt, and then they have to show damages. They have to be able to prove up the amount that's owed. So even if they're able to prove up that you owe the debt, then they have to prove up a specific dollar amount, and they may not be able to do that. Not only that, if it's a debt collector, that may be a great Fair Debt Collection Practices Act case, an FDCPA case, where if they're suing you for an amount that's not owed, you may have a claim against them. So you may want to look at that, and that only applies if it's a debt collector or a junk debt buyer, and they haven't given you proper credit for your payments. That'd be a pretty good case. So you may want to check that out. All right, Marcos, thank you. Appreciate you supporting the channel, coming in tonight. Let's talk about this one. Portfolio Recovery Associate sent a bill of sale, but there was no price. I requested the purchase order and was told I didn't need to know the purchase price. Is it legal? So if you, and some backdrop to this, junk debt buyers, they're saying that they purchased the debt. You request, they'll usually include a bill of sale, kind of a generic one, just a little one-pager thing that has some very generic information on it. But it'll often reference something called a master purchase and sale agreement, which is the document that really controls the relationship between the original creditor and the debt buyer. It sounds like if you got that, and then they redacted the price, I've seen that where they don't want people to see what they paid. The courts are going to usually allow that kind of redaction. The debt buyers will say that the amount that was paid by them for the whole portfolio of accounts is not relevant. And I've seen judges agree with that, saying that you don't need to know the price, just as long as there was something paid, what we call consideration for the contract, then that's going to be enough. But when you get that, that's not because it's not a very good argument to go in and just say, hey, judge, look, they paid 2 cents on the dollar for this thing. Now they want the whole amount. The courts don't care about that. What they care about is the accuracy of the information, the documents, and that your specific account was included. Because it's legal. It is legal to buy debt. It's legal to buy it at a discounted price, even an extremely discounted price like junk debt buyers do. But if you're going to come into court and say, hey, they owe me, they've got to be able to jump through all the hoops to show that not only that you had the original account, that you defaulted on it, they've got to show that your account was transferred between all the various entities, not just generally that there was a transfer, but that your account was transferred between those entities. They've got to be able to show that. And if they can't do it, they shouldn't be able to get a judgment. So you can kind of press the issue there more than what they paid for it, because even though it's outrageous and it's just, you're thinking, man, this is some kind of scam they got running here. The law allows them to do that if they negotiated a lower price for the debts. So something to think about there. All righty. Let's see here. Are you guys hearing me okay? I saw Dave said we might have a problem. Hopefully it's not the sound. We had sound problems a while back here. All right, let's take a look at this. See what Benny has to say. Man, I got to get my camera up a little bit higher here. In my opinion, do I feel like a plaintiff's lawyer is prepared to argue against the defendant if the defendant is ready to argue the affidavit or even attempt to defend themselves properly? The plaintiff's attorneys, here's the thing with them. They have done this, likely, most of them, assuming that they're not brand new to the practice. They've done it thousands of times. And so are they going to be prepared? I mean, they know the arguments, but the question is, you're going to have spent more time with the specific facts of your case. I had a hearing not just about a week ago in Superior Court here. The other attorney who I've gone against, I've probably done 200 trials against this attorney. He came on and he argued this issue that we were arguing before the judge. And it was clear he had not even looked at the documents prior to, because he was arguing things that really weren't relevant to it. Great person, he's a good attorney, but they do this a lot. And so sometimes they're not prepared, particularly if they're going against someone who's self-represented. They may assume that you're not prepared. And so that's why I would say, if you're not represented by counsel, you've got to be on time to everything. You'll see that their attorneys will show up 15 minutes late. I see this all the time. I show up to court and I'm sitting in a courtroom all by myself. Judge comes in, debt buyer's attorney's not there. and they'll say, well, we'll give them, 15 or 20 minutes. Whereas if I didn't show up on time, judgment would have been entered immediately. So you got to be on time, and you've got to be prepared to argue your case and the specifics. You've got to get into the details of it, not just generalities of that this just isn't fair. You've really got to be able to get into it. So, all righty, let's go ahead and let's go back to first name, last name here. Credit card lawyers are suing you, want me to sign a consent judgment for a payment deal. I have no property. If I file for bankruptcy in a few months, does the consent judgment ruin the discharge of the debt? Good question. So what you're going to see happens a lot, particularly if you're being sued by a creditor, debt collector, original creditor, and you're wanting to do some type of settlement where it's a payment over time. They're often going to want you to enter into a consent judgment. We sometimes will call them stipulated judgments, and sometimes they're called pocket judgments, where essentially what it is they drop a judgment for the full balance, and they put in there a term that says, hey, you're going to pay off X amount of dollars per month and on a reduced balance. And then there's also something in there called a covenant not to execute, which means they're promising not to garnish your wages or levy your bank accounts so long as you're making that monthly payment. And so we call them pocket judgments because we say, sometimes they put them in their pocket there as long as you're making the payments. But in the event that you default, then they will take the judgment and they'll just go file with the court and start garnishing you and collecting you. So as far as will it ruin the bankruptcy discharge? Typically, no. I mean, there's no collateral attached to it. The main thing you don't want to do is turn an unsecured debt like a credit card into a secured debt where there's collateral attached to it, because secured debts often will survive a bankruptcy discharge, except in a few cases. So if there's no property attached to it, which I don't see collection attorneys attempting to do that on just credit card debt, it'll still go away. It'll still be discharged. So, all right, Eduardo, thank you for supporting it. I sincerely appreciate that. All right, let's go to Homer Simpson here. Sued by CACH LLC. They have WebBank listed as the original creditor. Excuse me. And refer to Prosper as the original creditor in the affidavit. Can I dispute this in the court? Absolutely. Those are the types of details you want to be looking at as you go through this. I remember one time I had a case where the affidavit, where the person who was listed like in the first paragraph, like I said, I, John Skiba, declare as follows, and the person who signed it were two different people. That case got dismissed really quickly. If there's something like that where WebBank is listed as the original creditor and Prosper is they're showing Prosper somewhere else, those kind of discrepancies are the kind of things that you can win cases on. Now, sometimes you do have to look because like WebBank, I always say like Home Depot. If you have like a Home Depot credit card or a Walmart card, the bank is really Synchrony Bank. They're the kind of the underlying bank that's funding those cards. It could be something like that, but usually WebBank, they're their own thing. They're usually the underlying bank. But you don't want to see what the relationship between Prosper and WebBank are, but if there's a discrepancy there, absolutely. Those are the kind of details you need to be looking for. So, all right. This is a good bankruptcy question. In bankruptcy, what method do trustees use to determine home value? This is a great question because right now, bankruptcy is a little nuts because home values, particularly in places like Arizona, are just going crazy. But I know they are all over the country. And the issue with that is in bankruptcy, particularly Chapter 7 bankruptcy, you're trying to protect your assets. If you have a lot of equity in an asset, you want to see if there's an exemption law that will protect it. So in most states, there's a homestead exemption that protects your home. But usually there's a dollar amount tied to it. So like, for instance, in Arizona, there's $150,000 of equity is protected by the homestead exemption. That means if you go into bankruptcy in Chapter 7, as long as you don't have more than $150,000 of equity, they can't take your home. But what we're seeing is because the home prices are just going through the roof. I mean, you're seeing tens of thousands of dollars of equity each and every month that is jumping up. They want to know what method the trustees use to determine home value. Usually what I see the trustees in Arizona, they usually do a quick Zillow search. I don't know if you've been on Zillow. I know that if there's any real estate agents out there, you're losing your mind right now because Zillow is generally not considered, super accurate. But that's where they'll start because it's free. Bankruptcy trustees don't get paid a whole lot per case. They usually get about $60, and then they get a percentage of anything they collect. But they'll do a quick little search there, and if the values look at least in line with what you've listed on your bankruptcy schedules and you're within the exemptions, you're probably going to be fine. But if it's something where they jump online to Zillow, and there's some other ones that they can look at, they're just freebie things online. If it's way above, then they may look into it, and what they will often look for is what we call them broker's price opinions, BPOs, where we get a real estate agent to go out and give us an opinion on what they would list the house for. It's different than an appraisal, because particularly in a market like this, it's really volatile where prices are going up quickly. They want to know what would they sell them for today if they had to do it. So that's generally, at least in Arizona, what I see as far as how they value that. So, all right, let's see what else we have here. Let's look at Chuck. Midland Funding sued me. I hired a lawyer, and Midland immediately dropped the case. Midland then sent collection letters from a different account to claim they own. They haven't sued me yet. Oh, I've got to find the rest of this story. What should I do if Midland sues again or sends an intent to sue letter? Chuck, so I guess the question I would have is, so you got they dismissed the case. Is it the same lawsuit that they're coming back to you on? Because it brings up a good point. If you're being sued by a debt buyer and they offer to dismiss, or they're saying they're going to dismiss, two things you need to think about. You need to have the case dismissed with prejudice. That means it can never be refiled again. If a case is dismissed without prejudice, that means that it can be refiled. But you also need them to sign off on a settlement or a release. The release is what's saying that you don't owe the debt anymore. What I've said, and I've seen this happen. It even happened to me early on in my career, where they came in and said, "Hey, we're going to dismiss. We'll dismiss with prejudice." I was like, "Sweet, let's do it." And case is dismissed, client's happy, and then they're getting phone calls from the debt buyer. And the reason is because dismissing the lawsuit and getting rid of the debt are two different things. You need to do both. You need to get the lawsuit gone so they can't refile, and get them to release the debt or settle the debt so that it's not something that you're continuing to face. So if it's the same debt, then that's what you need to look at it, is if you release that or not. So, all right, let's do a bankruptcy question. I recently got my income decreased. Is there a risk to wait to file bankruptcy Chapter 7 until the 6-month income is below median income versus having to pass the means test? So if you're making too much, so Chapter 7 bankruptcy, you have to make at or below what a family of your size would make in your area. So I have 6 kids. I know that's a lot of kids. I have 6 kids, my wife and I, and so we have a household of 8. So if I'm going to file Chapter 7 bankruptcy, the United States Trustees Office puts out a listing of what a family of 8 would make in Arizona. And I have to make at or below that to qualify for a Chapter 7. So it's all the way from an individual up to however large your household is. So the question here is, if your income has recently gone down, is there a risk to wait to file bankruptcy until your 6-month income is below the median? The only risk, there's not a bankruptcy risk. If the choice is between filing Chapter 13 because you make too much money, or Chapter 7, if you wait a few months to get that overall average down, I usually lean towards getting clients into a Chapter 7. Clients are generally happy with Chapter 7s. There's no payback, and it's over fairly quickly. The only risk is the collections are going to continue until you file that case. Because if you file bankruptcy, it stops all the collections. In the meantime, they could be suing you, garnishing you, that kind of stuff. So that's going to be the only risk. All right, let's talk with this one with Kostas. I just realized the Suns game starts in 30 minutes, 25 minutes. We might have to wrap this up early tonight. All right, I'm going to be filing for bankruptcy soon. I have a leased Jeep Wrangler. My buyout is approximately $20K. How, with this crazy car market, is a car worth? How can I make this work? So, okay, so the buyout is $20,000, but they want you to pay $33,000. I may not understand this question. Okay, there's a follow-up here, I think. The lease company only give me the buyout price. To me, no dealer can purchase. I'm not sure if I quite understand how that's going to, as far as in bankruptcy. Here, let me tell you this about bankruptcy. And anytime you're buying a car right prior to filing bankruptcy, what you need to be careful of. Whatever you work out there as far as the price goes, I mean, that's not going to be impacted by the bankruptcy court. But you need to make sure that if you're loaning money on a car right prior to filing Chapter 7, that they put their lien on your title. In most states, there's the dealer has a 20 days, 30 days, 60 days, whatever it is, to put their lien on your title with the DMV. And if they don't do it, then in the bankruptcy court, the court can come in and take the car. And it's complicated, but they can go in and they have certain powers where they can void liens. So that's something just to be aware of as well. So, all right. I think that's probably going to do it. Like I said, we might end a little bit early tonight just because of the Suns game. We got to go support them. But I appreciate everybody checking in tonight. One last plug for some of the courses. I think a lot of you probably saw. I just released a new course earlier this week on how to use written discovery to get your case dismissed. Written discovery, like sending over requests for documents and information from the debt buyer. It's a powerful tool, but I often see it misused. It's underutilized in that it's not used correctly, if that makes sense. People try to get too many documents, so they send over these blanket things trying to get all these documents, and that's not what you want. The burden of proof is on them. They've got to prove that all those elements, that you had the debt, that they own it, how much is owed. You don't have to disprove it. But there are certain little things that you can kind of turn the knife that'll make them dismiss their case if you request certain documents that they don't want to turn over. Check that out. It's at the very top there. I pinned that to the links there about some of the new about some of those new courses. So go ahead. Oh, you know what? I got to do Rosinda here. Can a creditor sue you after they've canceled or closed an account? Great question. I'm going to end on this one. Often when an account is closed or canceled, they'll go 6 months and they'll do internal collections. They may do it themselves. They may farm it out to like a collection agency. They're calling, sending letters. And then at 6 months, they charge it off. Now, charge off is a tax thing. It's not something that means that they can't collect it. It doesn't mean they can't sell it, because what most credit card companies do nowadays is they charge it off, package it up, and ship it off to Midland Funding, Portfolio Recovery, somebody like that. So even if it's canceled or closed and they charge it off, they can still pursue it. I tell you, I've been in a billion internet fights on YouTube over this. There's some people that just believe that I am just leading people astray by saying that they can collect uncharged debts. I've got 20 years of doing this every single day, of dealing with nothing but charged debts to know that that's true. Anyways, all right. Sorry, I said that would be it, but I got to do Belinda. Belinda gave me the all caps, pick me. So we're going to do this one. Considering bankruptcy, should I complete my taxes first? Also, how soon after I file can I keep the money in my bank account without fear of the courts taking my money? This will be the last one, and this is a good question. If you have tax returns that have not been filed, it doesn't matter whether you're filing Chapter 7 or Chapter 13, get them filed before you file bankruptcy. It's going to make your life easier, your attorney's life easier, and that's what we're really concerned about, is the attorney's life. I'm just teasing. You get those filed first, because they can dismiss your case if you don't have the tax returns done. So get those filed. Also, in certain states like Arizona, if you're entitled to a refund and you file your taxes after you file your bankruptcy, that refund's going to get swept up by the court. If you get the refund before you file for bankruptcy, you can typically use that for, household things and, just general living expenses. So my recommendation, get those taxes done first. It's going to make your life a lot easier. As soon as you file the bankruptcy with the bankruptcy court, they immediately, an order comes into place. It's called the automatic stay. The clerks, the automated system literally kicks an order out immediately, and it stops any kind of garnishment, that kind of thing. So nobody's going to be able to go after your money in your bank account. Something that's an Arizona specific thing is on the day you file, you can only have $300 in your checking account. But that only applies to 1, Arizona, and 2, the day that you file your case, not every other day after. So with that, Belinda, we're going to end it. Thank you all for tuning in tonight. Appreciate all the support of the channel. Check back. I try to release a new video every Tuesday, and then we'll do these things every Thursday. And but I appreciate y'all checking in tonight. And we'll end it with a Go Suns.